Someone make it make sense.
Probably a couple.
Hello and welcome, guys. Party squirrels of the world unite. Yeah. So hope you guys are all having a glorious Saturday if you're on this side of the planet, or Sunday if you're on the other side of the planet. Shout out to the squirrels all over the world. I just got done hanging out with my family. My niece and nephew are just so super fucking cute. Love them so much. So we had dinner, and then the kids wanted to play animal dominoes, and it was really cute, and they're awesome. Both of the kids had made me presents, special rocks with decorative items on them. My niece gave me a rock with a unicorn theme, and my nephew gave me one with it said poop on it, and it had googly eyes. So there you go. They're amazing. But welcome everybody. Shout out to Twiz. Shout out to Iowa and Heather. Heather, haven't seen you in a hot minute. I hope you're doing okay. I've been worried about you. So yes, indeed. So we are here to talk Murdaugh and to go through this appeal. So far, I don't think anybody's gone through the entire appeal. So we are chipping our way through it. We left off on page 46 from part 1, which, by the way, part 1 is linked in the description if you missed it. And I very smartly added this blue line, teal line here, so I would know exactly where I left off, and it saved it, unlike when I did changes for Adobe with Idaho. So thank you, Adobe, for saving this edit, and now we know exactly where we left off. Also, this should redirect you guys automatically into the next live stream, which will be Adelson themed, right? So we're going to be watching Luis Rivera's police interview, Sigfredo, aka Alfredo's police interview, and Lewis's testimony from Katie's trial. And there's some really interesting things that I think are going to come out, that during Wendy's interrogation, you know, she there's certain questions where she gives way too many details and brings it up a whole lot of times, and it's like, what the fuck? And there's certain things that will make more sense when we hear some of this info, right, from the hitmen, as it were. So anyway, so that'll be coming up next. Also, shout out to Nightbot. Love you. Cutest one on the planet. Little Nightbot with his little hands and a big heart. And he has also his little festive tassels as well on top. So does anybody else share the same sentiment that whenever we talk Murdaugh, it feels like coming home? That's how I feel every time we talk Murdaugh. It is just my favorite thing. Also, I did add some more Wendy clips, but we're going to talk more about the Wendy things on the next live stream because Adelson. So for right now, though, let's do a celebratory swoop in honor of the road trip crew here. So let's see. Where are we at? Here we go.
It's a house.
Road trip crew plus the lolly bird, just, being thorough. So, all right. So we left off at a momentous point in this appeal, right? Right here. This is so epic, you guys. This was the momentous occasion when Chief Justice Toll, retired Chief Justice Toll, made her ruling at that evidentiary hearing where we all thought it was looking like he was going to get a new trial. And this is taken from the transcript of her ruling, so we'll just repeat this to refresh our memories. The trial court agreed, that's Justice Toll, ruling from the bench. I'm not conducting a Rummer hearing. Rummer is a 1954 decision of the United States Supreme Court that deals with the question of influence of the jury and a motion for a new trial on the basis of after discovered evidence of that influence. I rely on the South Carolina decision of our Supreme Court authored by Justice Kittredge in State v. Green. And the Green decision specifically says that Rummer is not the guidance that South Carolina trial judges should look to in conducting hearings on after discovered evidence. So just to recap, for some of you guys who probably will remember this, but it's been a while. So just to recap what's going on here, right? So I might sneeze. Uh-oh. Don't sneeze. Okay. I think we're all good. So what this is that there is a split between the states and the, I might sneeze again. Oh no. Okay. The states and the federal government as far as how this should be handled when we're dealing with potential jury tampering or jury influence from a public official. Okay. So this is a big deal. So going into this hearing, when was this anyway? I don't even remember. This was beginning of 2024, maybe. I'm sure the date is here somewhere. I think it was the beginning of 2024. So basically, all of Miss Becky fuckery, right? Yeah, it would have been the beginning of 2024 that this was January. Okay. So the Miss Becky fuckery happened in I think August of 2023. And so, it was looking like, okay, there's going to be potentially a new trial. And so what happened was at this hearing, right? When it comes to jury interference with a public official, okay, elected official, which in this case, Ms. Becky, right? Becky Hill. There's the two prongs, right? The first prong is did they talk to the jury? Did they say things other than what would you like for lunch? Or do you need to use the bathroom? Did they say anything? Did they communicate, right? That's the first prong. The second prong is, did it influence your verdict? Now, here's the distinction. So the South Carolina Supreme Court has ruled via case law, right, that in order to say, okay, you need a new trial, it has to meet that second prong, as in it needs to be shown that the verdict was influenced, okay? Now, in the federal government, right, only the first prong need be met. So, and interestingly enough, the circuit court that, in terms of the jurisdiction, where the low country of South Carolina happens to be in the same circuit as where I live, which is wild. So in other words, and this is why this is going to make it the Supreme Court, my view, right? Because essentially, and it's not just South Carolina, it's other states, it's all the states, right? They all have their own case law, right? So what has happened thus far, right, is that only the appellate courts, the federal appellate courts, which in our government here is the circuit courts, right? The appellate courts have ruled on which prong should be used, right? So what they looked to in South Carolina here is the circuit that applied to them, which I believe is the Fourth Circuit. But what has not happened is none of this has never made it to the Supreme Court. Now, what I mean by that is this. It's never been that a case has appealed all the way up to the Supreme Court, where the Supreme Court has then ruled this is the standard. Is it one prong or two prong? Because if that were the case, that would then be the law of the land for the entire country, no matter what, okay? That would finalize it. There's no longer a question, right, as to if it just has to be, did you interact with them, or second prong, did it influence your verdict, right? So that's the issue here, because when you're dealing with the state, right, like here, what happens in the federal appellate courts is not mandatory binding authority on the state Supreme Court for any state, okay? It can be considered persuasive, but it's not binding, right? So if you're within one state, right, if you're a trial court or an appellate court within one state, what's binding to you within that state is your state Supreme Court, or it has to be the U.S. Supreme Court. Again, the federal appellate court level can be considered, it's persuasive, but it's not binding. So that's why it's a huge deal that they're saying, yeah, so our federal appellate court, right, I think it's the Fourth Circuit here, has said, we go by that, we need that, only that first prong has to be met. However, that's not binding on us being the South Carolina courts, because we follow, unless the U.S. Supreme Court rules, we follow State v. Green. That's that's South Carolina Supreme Court case law. That's what they follow. Remmer is the federal appellate level case law. Again, I think it's the Fourth Circuit. So while a lot of people were kind of giving Justice Toll crap, saying, if there's any appearance of impropriety, go ahead and it should be a new trial. And I understand that logic, But the part that a lot of people were missing is how it works when you have to follow the mandatory binding authority. And for Justice Toll at the trial court level in South Carolina, that binding authority is going to be the South Carolina Supreme Court unless and until the U.S. Supreme Court weighs in on this issue. So hopefully that makes sense to everybody. Huge. No, that's mean, Twiz. Oh, are you talking about? That's funny. Paganini had huge hands. Anyway, I'm not going to go off on a Paganini tangent. Okay. So anywho, so right here, so this is, they're citing Justice Toll's ruling, okay, where she said as much as what I just was explaining. And it's a big deal. I mean, again, I think this is going to make it to the Supreme Court. And if it does, this will be the first time this issue has been before the U.S. Supreme Court, where this matter, this issue, this split, if you will, between the federal courts and the state courts will be settled once and for all if it makes it that far. Because whatever they decide, that's it. Then that's case law, right? Regardless of what it is they decide. Okay. So pre-hearing, the South Carolina Supreme Court said very clearly, we do not go by the guidance of the 1950s U.S. Case of U.S. v. Remmer. Again, because that's the federal appellate court. Its state drafted order entered months after the evidentiary hearing, however, hides its reasoning, stating only that Murdaugh argues prejudice must be presumed under Remmer, while the state argues that the overwhelming weight of the South Carolina case law is clear that the burden is on the defendant to show not only the improper influence occurred, but also resulting prejudice. So this is important because this was also a factor here, right? Which is this, that when it comes to after discovered or newly discovered evidence, and by the way, that has come up in Karen Reed too recently, right? In a different way, but yeah. And I think also, wait, no. Well, I guess that kind of came up, but I'm thinking in Richard Allen's case, right? So anyway, but what they're talking about here is that the defendant in this situation, right, from South Carolina case law, the defendant has to show. So the burden swaps, the burden switches, right? And that's very oftentimes the case. Once you get, if and when you get convicted, right, of a crime, and you move into this appellate process, now the defendant is always going to have the burden to show something, which is why they always say it's better to not get convicted. Because sometimes you'll see people say something like, oh, well, maybe they're doing this on purpose because they are just like, oh, we'll have a better case on appeal, as if to say that that's better than not getting convicted, right? Totally not the case. Before you're convicted, the burden is always going to be on the state. Once you're convicted and you move into that appellate process, now the burden is on the defendant to prove things, right? So same thing here, right? The burden is on the defendant to show not only the improper influence occurred, but also the resulting prejudice. That's the two prongs. Improper influence being the first prong, resulting prejudice as in influencing the verdict. That's that second prong. Okay, the trial court's order then proceeds to review the South Carolina cases, some of which are arguably irrelevant. For example, cases dealing with external influences not touching on the merits of the case before the jury or alternate jurors participating in deliberations, and some of which are arguably irrelevant, without attempting to explain why Remmer is not good law. This is an argument being made by Murdaugh's defense team. Another interesting side note here, this is highly unusual. Murdaugh still has the same defense attorneys, right? Poot and Jim Griffith. Never happens, ever. You always have different attorneys for the appeal. This is highly unusual. And that's an understatement. He's got the same attorney. So just throwing that out there. But also, I mean, I don't think this is a strong argument for them, because it's not that Remmer is not good law. It's that it's the wrong standard to be applied, right? As for reasons I just explained. Okay, to be sure, the continued viability of Remmer is not universally agreed. Yes. Oh, here we go. Keep reading, Chelsea. There's a three-way federal circuit split on the issue. Bam. The majority position adopted by the 1st, 2nd, 3rd, 4th, 7th, 9th, 11th, and DC circuits, and at least 28 states, presumes prejudice under Remmer. Although many courts, like the 4th Circuit, so I was right about the 4th Circuit, okay, and this court in Green declined to apply it categorically to innocuous contact with jurors. Right. So again, if it didn't influence their verdict, it's considered innocuous under the Green case law, right? And they're citing all these cases. So let's take a look at these footnotes. The Remmer presumption does not apply to internal influences on the jury. And Mr. Murdaugh has not sought any relief based on the alleged improper internal influence on the jury. The Fifth Circuit may have since moved back to the majority position. And it says here, to be entitled to a new trial based on an extrinsic influence on the jury, a defendant must first show that the extrinsic influence likely caused prejudice. And then the government then bears the burden proving the lack of prejudice. That's interesting. So that's putting the burden back on the government for that second prong. Hi, Cece. Happy to see you again, my friend. Okay, in 10th circuits and at least 14 states declined to apply Remmer and instead require defendants to prove prejudice as the trial court held. The 8th Circuit and at least 7 states leave the question entirely to judicial discretion. As the state argued, the question driving the split is whether Remmer was narrowed or overruled by Smith v. Phillips and United States v. Olano. The court should decline the state's invitation to join the minority position on the question for 3 reasons. First, the argument that Olano or Phillips abrogated Remmer is unpersuasive, which may explain why that argument remains the minority position 30 and 40 years after those decisions, respectively. In Phillips, a juror applied for employment with the district attorney's office during trial. Oh, wow. But the prosecution did not disclose the fact until after trial. In Olano, the trial court permitted alternate jurors to attend, but not to participate in jury deliberations. Interesting. Now that, remember you guys, for Richard Allen, that was allowed. Well, there are a lot of anomalies there for that, but the alternate jurors were allowed to attend but not participate. In each case, the Supreme Court held that a new trial was not required, but neither case involved an external influence on the jury from anyone other than alternate jurors. So what they're trying to do here, his defense team, is make a distinction, right, as to why that's not applicable case law. When you're making an analysis, right, of the case law to apply, right? IFRAC, right? Issues, that's your legal issues, right? Facts, research analysis, conclusion. So the facts is the F, right, in IFRAC. So you try to find case law that is factually similar as possible. Sometimes it's not going to be spot on, right? But in certain issues like this, right, that's an important distinction. Was it an external influence or an internal influence? Both cases cited Remmer with approval. In Turner, prejudice was presumed where the jury was in charge of the sheriff's deputies, who were also prosecution witnesses. A fact pattern. There we go. Fact. Speaking of facts, fact pattern with a close similarity to the present case. Second, only the U.S. Supreme Court, here we go, can decide whether it has overruled its decision in Remmer. It is this court's prerogative alone to overrule one of its precedents. The court cannot decide that the U.S. Supreme Court has overruled a precedential decision by implication from later decisions that appear to use inconsistent reasoning. Quote, our decisions remain binding precedent until we see fit to reconsider them, regardless of whether subsequent cases have raised doubts about their continuing vitality. Third, the court should defer to the Fourth Circuit's interpretation of a question of federal constitutional law, especially when it adopts the majority position. The Fourth Circuit's position is clear. Some courts have suggested that post-Remmer developments narrowed or overturned Remmer's presumption of prejudice. So that presumption of prejudice, again, remember, this is the case law that his defense wanted to go with, right? Because of the presumption of prejudice. As in, if there was any words said that were not just have a nice lunch or what the fuck, like presumption of prejudice, right? Like I was saying earlier, but that's the federal, right, case law. So the Remmer presumption of prejudice cannot survive Phillips and Olano, but the Fourth Circuit continues to adhere to a Remmer presumption when the contact goes beyond the innocuous. They keep referencing this. Holding that where an unauthorized contact was made with jurors of such a character to reasonably draw into question the integrity of the trial proceedings, the defendant is entitled under Remmer, 1, to rebuttable presumption that the external influence prejudiced the jury's ability to remain impartial. Holding that Remmer is clearly established federal law. And so let's take a look at this footnote here. Moreover, while South Carolina's courts are not subject to the mandate of the Fourth Circuit, right, like I was saying, right, they must follow what the Fourth Circuit says is clearly established. This is, I mean, I don't know. We'll see. I don't think this is going to work out too well, but, they have to make the argument. is clearly established federal law regarding the rights of criminal defendants in the state or writs of habeas corpus may be granted. Okay, now they're citing here. So this is the United States Code, okay, providing for a habeas writ where state court proceedings resulted in a decision that was contrary to or involved an unreasonable application of clearly established federal law as well, there you go. As determined by this, they have to cite the entire thing. Are they just pretending this part doesn't exist? As determined by the Supreme Court of the United States. That's the part that we're missing here, Putin Jim. Hasn't happened yet. The Supreme Court has not weighed in. Okay. So yes, this court's decisions addressing such external influences on a jury's deliberations reflect that the Remmer rebuttable presumption remains alive and well in the Fourth Circuit. To determine whether a contact with a juror is innocuous or triggers the Remmer presumption, we look to whether there was one, any private communication. Okay, this is important. Let me just point out, this is important because this is going through, when do we know if the contact was innocuous? Okay, so 1, was there any private communication? 2, was there any private contact? 3, was there any tampering? 4, was there directly or indirectly with a juror during trial? 5, about the matter before the jury. I feel like there's some verbs missing there, but whatever. Okay. 2 years before the Fourth Circuit's Albaz decision, this court in Green considered a case in which a juror asked a bailiff what would happen if the jury deadlocked, and the bailiff responded that the judge probably would give an Allen charge and ask him to stay later. The court held. The trial court questioned each juror and the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. Yeah, I would say that seems to be the case. Our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. Now, you might be wondering, why are they talking about bailiff? Because Miss Becky is in a unique position here, being that she was a clerk of court. And so far, there is literally no case law that deals with a clerk of court, talking to the jury, influencing the jury, any of that. The closest thing factually, again, thinking about IFRAC, the closest thing factually of which to reference for the case law would be the bailiffs having communications with the jury. So that's why whenever you see the bailiff, just in your mind, you can think, okay, yeah, they're using that kind of synonymous with the clerk of court. So not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. In Remmer, a juror was approached by a person unnamed and told that the juror could profit by bringing in a verdict favorable to the defendant. The federal district court, without holding a hearing, denied the defendant's motion for a new trial. Ultimately, the Supreme Court recognized the presumption of prejudice from the highly improper juror conduct and remanded to the federal district court to hold a hearing. That's the Remmer hearing. Hold a hearing to determine whether the incident complaint, and that's literally what happened in this case. They had the hearing. The attempted bribery of a juror in Remmer, conduct which goes to the heart of the merits of the case on trial, is a far cry from the circumstances presented in this case. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. Okay. The trial court read that language to hold that South Carolina courts never apply the Remmer presumption of prejudice in any circumstances. So here, they're referencing the trial court as in Chief Justice Toll, as in this case. They're kind of saying that she read the case law wrong. Green is the only reported South Carolina appellate decision discussing Remmer, and the trial court's reading of it plainly erroneous. Again, so there it is, even more plain, right? They're saying Justice Toll was plainly erroneous, basically. Let's see what this footnote says. Footnote 9. Oh, okay. Well, we don't need to read that. Okay. While we decline to adopt the Remmer presumption of prejudice in every instance of an inappropriate bailiff communication to a juror, does not mean we decline to adopt the Remmer presumption of prejudice in any instance of inappropriate communication to a juror, nor does our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. No inappropriate comment to a juror ever rises to the level of constitutional error. I don't think that's how that was interpreted, but okay. A more reasonable reading is that the court's opinion is identical to the Fourth Circuit's opinion expressed in Albaz 2 years later. Prejudice is presumed unless the contact. Again, this is switching the burden. This is switching the standard. Like I was saying, remember how I was saying how like a lot of people that were commenting on this prior to the hearing were saying, yeah, that it should be presumed prejudicial, right? Like it should be presumed, like even the appearance. And again, That makes sense logically. The problem is that's not what the case law says, that in terms of what is binding upon this court. So presumed unless the conduct is innocuous or does not touch the merits. This is also consistent with the earlier opinion of the Court of Appeals in Cameron, which held in this case there was private communication of the court official to the members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury is to be maintained. When there has been such a communication, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The trial court refused even to consider Cameron because it is a Court of Appeals decision. And then this is quoting Chief Justice Toll, I do not regard State v. Cameron as the guidance that needs to be used by me in making a determination about this case. It is a Court of Appeals case. And because in its view, the later Green decision held that Remmer is no longer good law. Similarly, in Bryant, the only South Carolina case other than Green to cite Remmer, the court held that the defendant must prove actual juror bias. Right. And this is what they had the hearing for, which he did by proving the questioning of jurors, family members by Horror County. Again, this is a different case, but the standard that they used. So questioning the family members of detectives in a case in which the victim was a police department officer was at a minimum an attempt to influence the jury, and that could have been perceived as an attempt to intimidate jurors. The jury intimidation was an actual prejudice that the defendant had the burden to prove. There was no suggestion that having proven law enforcement officers engaged in jury intimidation, the defendant then needed to prove what the verdict would have been but for the intimidation. Okay. The presumption of prejudice is irrebuttable when a state official tampers with the jury during a criminal trial about the merits of the case. Well, the problem here is that they can't back this up with mandatory binding authority, right? Okay. Having proven with that Miss Hill communicated with at least one deliberating juror about the evidence presented during his murder trial, Murdaugh has established that he is entitled to a new trial. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. Cameron requires that the subject matter of the communication between an official and a juror be harmless, clearly harmless. Otherwise, a new trial must be granted. When, as here, it is proven that a state official has told jurors not to believe the defendant when he testifies, the state cannot rebut the presumption of prejudice by arguing what the outcome would have been without that tampering. Ms. Hill was a state official who used her official authority to obtain private access to jurors so she could argue the merits of the evidence outside with the presence of the court, the defendant, and his counsel. This is fortunately a rare event, but it is one that requires a new trial. The Court of Appeals distinction in Cameron between the communication itself being harmless and the subject matter of the communication being harmless, and its requirement that a new trial be granted unless the latter is established, recognizes that deliberate jury tampering by a court official cannot be cured or excused by the strength of evidence presented at trial. The U.S. Supreme Court addressed this exact issue almost 60 years ago when it held the Sixth Amendment right to a trial before an impartial jury is incorporated to the states via the 14th Amendment. The Supreme Court of Oregon held, well, who cares? It's not binding anyway. Okay, the Supreme Court of Oregon held the statement did not require a new trial because it was not shown that the statement changed the outcome of the trial. The U.S. Supreme Court reversed, holding the evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. And we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of constitutionality of a fair trial. In Parker, the state also argued that the bailiff statement was harmless because 10 members of the jury never heard a statement, and Oregon law at that time allowed a guilty verdict by 10 affirmative votes of the 12 jurors. Oh, interesting. They only require 10 out of 12. Wow. The state of Oregon argued, as the state does here, that the jury tampering does not require a new trial, or did not, rather, because the defendant did not show the verdict would have been different but for the improper communication. In Parker, that was almost mathematically certain. 10 jurors never heard the communication issue, and the vote of 10 jurors was, at that time, enough to convict. Yet the Supreme Court rejected that reasoning and, after questioning whether the factual record supported that argument, stated that in any event, petitioner was entitled to be tried by 12, not 9, not 10, impartial and unprejudiced jurors. That reasoning accords with the reasoning in Cameron 27 years later. The right being protected is not the right to a correct verdict, but the constitutional right to a trial before a fair and impartial jury free from state officials' improper influences. The Court of Appeals more recently touched on this point in Green, holding a bailiff's comments were presumptively prejudicial because of his official position. So what this is saying is that, like, oh God, stupid. What this is saying basically, right, is that when you're in that position, and this has come up before here, right, such as a Miss Becky, such as a bailiff, such as a judge, anything, even the attorneys, right? Like if you're a if you're a juror, right, and there's comments that are made to you by one of the court officials, say, right, you're going, I mean, well, most jurors are going to find that to be, they're going to look at to them almost as an authority figure, even though they aren't really, like they're not an authority figure to the jury, but they're going to give that more, well, likely give that more weight than, say, if it was anybody else, say, I don't know, their sister or whatever, a person off the street, right? That's what they're saying here because of the official position, right? But that the state rebutted that presumption by showing for various reasons that the remark did not, in fact, influence the outcome of the jury's deliberation. So they were like, nah, we don't care what the bailiff says. This court affirmed but modified the decision to correct the Court of Appeals reasoning. The communication was not prejudicial because it did not, in fact, change the verdict. And this is, again, what we've been going to here. That is what the heart of this was, right? That it did not change the verdict is what was found by the trial court here. Instead, it was not prejudicial because the subject matter of the communication was harmless. So, okay, so they're trying to make a distinction, they as in Poot and Jim, that the reason the court affirmed is not because the communication did not change the verdict. It's because the communication was harmless. The bailiff's actions here, though improper, did not touch the merits, but only dealt with the procedural question of how the judge might handle a jury impasse that apparently never materialized. A bailiff presuming to tell the jury that if it's deadlocked, the judge will instruct them to keep deliberating is improper, but likely harmless because the subject matter. So again, improper, right? Because they shouldn't be saying anything like this at all, right? But likely harmless. And if it sounds like it's splitting hairs, that's because it basically is in order to figure this out, right? Again, this is an issue that has not come before the U.S. Supreme Court before, okay? It's a big deal. Okay, because the subject matter is procedural or logistical rather than to the merits of the case. Here, by contrast, and they're saying here as in this case with Murdaugh, right? The extensive, deliberate, and self-interested jury tampering with which has been proven by Miss Hill committed far exceeds the simple bailiff mistakes that forced a retrial in Cameron, where a bailiff's misleading response to a juror's question about sentencing options compromised the jury's impartiality because it left the impression that their verdict could not affect the trial court's sentencing decision. I'm not going to read the next one. Finally, state and federal courts have found the authority of the speaker to be relevant. Okay, again, back to this thing with the authority, right? The authority of the speaker. Again, here, the clerk of court, Becky Hill. The authority of the speaker to be relevant to the Sixth Amendment analysis of improper external communications with jurors during trial. In Parker, the U.S. Supreme Court noted that the state's argument that no harm could have resulted from a bailiff's comments on the merits overlooks the fact that the official character of the bailiff as an officer of the court as well as the state beyond question carries great weight with the jury, which he has been shepherding for 8 days and nights. That's like what I was just trying to say. For that reason, undue contact with a juror by a government officer almost categorically risks influencing the verdict. Let me read that again. For that reason, undue contact with a juror by a government officer almost categorically risks influencing the verdict. Now, again, if you're thinking, yeah, this makes sense. This seems like I agree. What's the problem here? The problem here is this. They're citing federal case law from the Ninth Circuit. Not binding on this court. Yay, Candace. How's it going, my friend? Welcome, Candace, to the Squirrel Party. Okay. Here, the improper communications about the merits of the case did not come from a bailiff acting as a security guard or as a message courier. Wow, I haven't seen that word in a long time. They came from an elected official. Now, they italicize this for a reason, right? Because Miss Becky was an elected official. Someone whose name nearly every one of the jurors presumably had seen on the same ballot they used to vote for the president of the United States, holding an office established by the state constitution. It was the very person who summoned the jurors to serve, who impaneled them and administered their oath, who administered the oath to the witnesses presented. Oh, and look at this footnote here. Check it out. Miss Hill was elected in 2020. The voter turnout in 2020 general election in Colleton County was over 73% of all registered voters. So what they're saying is that's how many people would have been like, oh, we know Miss Hill, Miss Becky. We know Miss Becky. I mean, they would have known her anyway from like going to church and like baking cookies with the granddaughter and whatnot anyway, but so ministered the oath to witnesses presented to them for their consideration, who told them when and where to report each day for their service, and who read their verdict in the courtroom. Subsection A. The state cannot rebut the presumption of prejudice by arguing Ms. Hill's jury tampering was harmless because secret advocacy for guilty verdict in the jury room during a criminal trial by a state official is a structural error in the trial that cannot be harmless. Now, these are the magic words that they're trying to use here. Structural error, right there. That's key, right? Structural error, right? Okay, sound the alarms, right? In the trial that cannot be harmless. Sound the alarms again, ring-a-ding-a-dingy. Sustaining a conviction based on the court's opinion of the strength of the evidence against the accused, regardless of improper external influences on the jury from court officials about the merits of the case, is effectively a directed verdict for the prosecution. This is them making argument, right? This is not case law. This is their argument. A statement that whatever happened at trial simply does not matter because the evidence can admit only one result regardless. That would be structural error. And now they're giving some case law, but again, it's not verbatim what they just said. That was their own argument. When the jury returned guilty verdicts in this case, the trial court Okay, so this is important because this is, I think, quoting Judge Newman. Yep. This is quoting Judge Newman. So they better be careful here because I'm telling you, I will come for them if they try to make Judge Newman look like a villain here. Okay. When the jury returned guilty verdicts in this case, the trial court congratulated the jury that, quote, certainly the verdict that you have reached is supported by the evidence, circumstantial evidence, direct evidence. All of the evidence pointed you to only one conclusion. That's the conclusion you all have reached. So I applaud you all for coming to a proper conclusion. So this was it. I think it's sentencing, but what is it going to say here? Even before that was, or I guess it was at the verdict, but well, actually they did the sentencing immediately after. So I don't know, but that's Judge Newman. That's quoting Judge Newman. Even before Ms. Hill's misconduct was known, the trial court foreshadowed the outcome of the harmless error analysis as it applied to Murdaugh's new trial motion. The trial court held that Ms. Hill's jury tampering could not in any way undermine the fairness and impartiality of the 6-week trial with its extensive evidentiary presentations, arguments from counsel, and instructions from the trial court, and any possible presumption of prejudice was overcome by these facts. And so that's quoting Chief Justice Toll when she denied the motion for a new trial. But the prejudice at issue, whether it is presumed or must be proven, is not an incorrect verdict. Shout out to Kane. Happy you're here again as well. Jury tampering is prejudicial if it denies the accused a fair trial. The strength of the state's evidence against the accused cannot cure the denial of his right to a fair trial. Now, I agree, right? So what they're saying here is this. They're saying that, okay, let me just break this down. Prior to the Miss Becky fuckery was known to the world, right? Judge Newman commented on the strength of the case, okay? Which I agree. But anywho, and so but then Chief Justice Toll, when she said this, I was like, oh no, this could be problematic. Justice Toll did comment on this, she did reference what Judge Newman said. And I was like, fuck, because it wasn't necessary, but now it's giving them something to argue, which is this, right? That they're going to argue, well, they are arguing, we just read it, that the strength of the case, as said from Judge Newman, right, was a part of her decision to deny the motion for a new trial. And so again, the strength of the state's evidence against the accused cannot cure the denial of his right to a fair trial. Okay, thus the rule for deciding whether to grant Murdaugh a new trial is not whether the trial court believes the outcome of the trial would have been the same had Ms. Hill's jury tampering not occurred. If that were the case, the trial court should deny a motion for a new trial, even if she paid the jury to vote guilty, because in the trial court's opinion, all of the evidence pointed to only one conclusion, the guilt of the accused. Now, I feel like that's a bit much. That's a bit of an exaggeration there. That's not what she was saying, okay? I have a request. Do you have a bedtime song? Kane's asking me to sing him to sleep. Okay, and again, it's so funny, right? Because again, where I live, I'm in the 4th Circuit in terms of the federal circuits. So funny, right? Because like not close to the low country of South Carolina. But anyway, the Fourth Circuit very recently made a similar point when overturning a Murdaugh-related criminal conviction. They're talking about, what's his face, Russell Lafitte. This makes me happy though, right here. A Murdaugh-related criminal conviction. Like the fact that this is his defense attorneys and they're calling it a Murdaugh-related criminal conviction. Like they didn't even have to say that. They could just say they just overturned a conviction, but a Murdaugh-related, I mean, that just sum it up so nicely right there. The scope of this is so great. By great, I mean big and also insane. Because of a violation of the defense. So this is, there it is. Yep, U.S. v. Lafitte. So that's Russell Lafitte. The Fourth Circuit held that the trial. Now, I will say this is completely different. I don't really know why they're bringing this up because nothing related, nothing completely unrelated. So everything about it was completely different, and there was no question that he needed a new trial after what happened with this. And if you guys want me to cover that, I can, as long assuming I can find the documents, but I think I can. But there was no question, like new trial for him. Okay, violated the defendant's right to an impartial jury because there was a reasonable possibility that the removal was related to the jurors' views on the merits of the case. The government argued the violation was harmless. The Fourth Circuit held that it need not reach the issue of whether the Sixth Amendment violation was structural error because even under the harmless error standard for constitutional errors, the government bears the heavy duty of proving beyond a reasonable doubt that the error complaint. So part of the issue here, so here's what I'm gleaning from this, right, guys? Part of it is, so there's a lot of things here. It's not just the prongs, right? There's also seems to be a discrepancy over who bears what burden when it comes to this. Like, is it the state's burden to prove there wasn't an undue influence? Is it the defendant's burden to prove there was? And it just, depending on which, and this is why it's going to go to the Supreme Court. Because depending on which court, and by that I mean jurisdictionally speaking and level within said jurisdiction, depending on which court you go to, it's all different. The prongs are different, the burdens are different, and this is exactly why the U.S. Supreme Court is going to have to settle this issue, right? Twiz is protesting. Don't go to sleep yet. So this is a huge deal, guys. You know, it's so funny because there's like two cases right now that I'm covering that I think, I mean, I would say nothing is for certain in life, right? But I would say 99.99999% or thereabouts certainty are going to make it to the U.S. Supreme Court. And that's Murdaugh and that's Bryan Kohberger. Because both of these cases have new issues. Like, well, okay, it's new issues with BK because of the IgG and stuff, right? But like with this, and again, this is only if that, in that case, only if there's a conviction, right? But with this case, it's not that it's new issues, but it's issues that have not been decided. And so it's old issues, but issues that you see what I mean? Like, so either way, in both of those cases, it's not oftentimes that you see that where it's like a case of first impression in a way, right? Like, and again, here, the case of first impression would be when it gets to the U.S. Supreme Court, because again, they've not ruled on this yet. So it'll be first impression for them. The Fourth Circuit rejected the government's argument that the strength of the evidence submitted during its case in chief was sufficient to render any error harmless under that standard because the defendant presented defenses and whether the jury credited his testimony was at the heart of those defenses, and the jury, not this court, is tasked with evaluating the evidence and deciding whether the government has met its burden. Likewise, in this case, the state cannot cure the absence of an impartial jury at trial by asking a trial judge or an appellate court to evaluate the evidence it presented at trial and move the missing impartial jury. So that's an important thing as well there, right? Like, what they're saying is that the issues here are also affecting his appeal because of the fact that it's skipping. It's like trying to build a house and put the roof on first before the floor, right? They're saying that here he is, this is his appeal, but he's already prejudiced, right? Because the appellate court normally evaluates the evidence. However, what they're arguing here is that, wait a second, they can't be getting to that point. That's the roof, right? The floor is the impartial jury, and that's what they're saying that's missing, right? This case, however, is distinct from Lafitte. I don't know why they're bringing Lafitte into this, honestly. Although it is funny, but in that Miss Hill's jury tampering is so far beyond the pale of that the court should have no reason to be reluctant. And here I will say, I disagree. I think the issues that happened in Russell Lafitte's case were way worse. Not even a question. Not even a question. The structural error is like not even, it's a no-brainer. Anyway. The issue here is not whether a judge erred in dealing with a jury issue during trial. Or sorry, not whether a judge erred in dealing with a jury issue during trial, nor whether a juror engaged in misconduct, nor whether some member of the public engaged in misconduct, nor whether a defendant engaged in misconduct, nor even whether a bailiff made an improper statement. Wow, that's interesting statement or sentence. The issue is whether an elected state official using the power of her office to enter the jury room during trial to advocate against the defendant to promote her own financial interests is a structural error in the conduct under the trial, under the principle that all evidence and argument presented to the jury must be presented in the courtroom. So that's a new way to frame this, okay, that I'm hearing from them. So this is a new side of the coin, if you will, which is saying, again, it's odd that he's got the same attorneys for this appeal, but whatever. Anyway, what they're not doing a terrible job. Like, in other words, this is another facet that they're bringing up, which is this, that, apart from the prongs, like we talked about, apart from whose burden and what, when, and all that, right, which we talked about, there's this another facet, which is this, that all of the evidence at trial must be presented in the courtroom. They're right? The difference here is who's going to see. They're arguing, right, that what Miss Becky did with the jury counted essentially, right, as evidence presented to the jury. And again, what did they just say before this? They went over the whole thing about the public official, the authority figure. They're trusted, they're respected, and all that, right? They laid that first so that they can say, well, that's the reason why then when this person says something to them outside of the courtroom, they're going to take that to heart and it's going to mean a lot, right? And therefore, it's as if you're presenting evidence not in the courtroom, right? Now, the other way to see it is like, well, that wasn't evidence, or depending on the prongs, maybe it was evidence, but it didn't influence their verdict. So this is why it's like, it's a layered issue here. The undisputed evidence and findings from the evidentiary hearing are that Miss Hill did engage in jury tampering. That's true. That is now on the record. That was put on the record from Chief Justice Toll. Chief Justice Toll said about Miss Hill, I did not believe her. Her words were untruthful. She was, what was it? She was corrupted by the siren call of celebrity. Something like that, right? She fell, and hold on. It's like she gave into the temptation. Oh my God. She gave into the temptation of the siren call of celebrity. That's like what she said. Yeah, it's on the record. So Miss Hill, yeah, there you go. 3 jurors and the alternate juror testified that Miss Hill made. Now, this is where it got really fucking interesting during that hearing, you guys, right? Jersey. All right, 3 jurors and the alternate juror testified that Miss Hill made comments to them regarding the merits of Murdaugh's testimony and in his own defense. 1 juror and the alternate testified she told them don't be fooled by the defense. The only witness to contradict any of that testimony was Miss Hill, whom the trial court found to be not credible. 1 juror even testified that Miss Hill's conduct did influence her decision to vote guilty. Well, she later recanted that. Are they going to include that part? Miss Hill's conduct would necessarily bias a jury against the defendant. It was an abuse of discretion for the trial court instead to reason that it does not matter whether that happened because of any jury, biased or unbiased, would reach the same verdict in this case. The right at issue is the constitutional right to trial before an unbiased jury, not a right to correct the verdict. This is really fucking interesting because what's going to happen eventually, as y'all know, the appellate process takes forever. What's going to happen eventually is there's going to be oral argument on this in front of the appellate court, and I can't wait. I need to look into that and see if they're any closer to, if there's anything happening. I mean, who knows how long it'll take, right? But this is really, again, I have to say, these issues are real issues, right? The real question is, I think that it's going to come down to is which court is the court to make this decision. And again, I think it's going to be the U.S. Supreme Court. That's what I see happening. What I see happening, if I had my squirrely crystal ball, which I always have, into the future, is that the appellate court is going to deny it. And they're probably going to say something similar to what Chief Justice Toll said, which is, this is not my decision to make. this needs to go to the U.S. Supreme Court. And off it goes. And that's what I think is going to happen, because that's given the difference, again, in all the different case law from all the different jurisdictions and court levels. There's a reason it's a mess. So all that to say, it's going to be really interesting to watch this go through and play out, and to see the argument, and to see, it's so interesting whenever you get to watch appellate courts, whether it's, a court of appeals or a state Supreme Court or a U.S. Supreme Court. I freaking love listening to that, because it's really interesting the way it's done. And they really go hard on the attorneys, Anyway, I'm not going to I could go on and on about how interesting I find that, but that's going to be happening with Murdaugh, guys. Road trip crew. All right. It has long been held to be a structural error for a state actor to engage in ex parte advocacy during the jury trial, to the jury during trial. So ex parte, right? So like not with the attorneys. The requirement that a jury's verdict must be based upon the evidence developed at the trial goes to the fundamental integrity of all that is embraced in the constitutional concept of a trial by a jury. The evidence developed against a defendant shall come from the witness stand in a public courtroom where there's full, and again, some of this might be a bit redundant because this is kind of what they've already said, but they're quoting a different case law here with this, right? Where there's full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. Actually, no, I think they already did cite that same case law. And in Simmons v. South Carolina, the U.S. Supreme Court similarly held it as unconstitutional for the defendant to receive the death penalty on the basis of information which he had no opportunity to deny or explain. Well, yeah, obviously, but I don't know that that's relevant here. The principle is ancient and foundational to our system of trial by jury. In the ultimate analysis, only the jury can strip a man of his liberty or his life. In the language of Lord Coke. Lord Coke. Well, now we have to learn who that is. It is what it is, guys, right? We need to know who Lord Coke is, clearly. Okay, let's do a little searchy search. Okay, excellent. It's just... Oh, did they already talk about Lord Coke? Because now I feel like he rings a bell. Okay, so, hold on. Okay, was this what you guys were expecting? Lived from 1552 to 1634. This gives me J. Logsdon vibes, which I love. He was an English barrister, judge, and politician, often considered the greatest jurist of the Elizabethan and Jacobean eras. Lord Coke. Interesting. By the way, this is one of my favorite time periods as well, when he was living. I would say he was just after. I mean, I love Tudor England is like my jam, and like this is like just after that. Well, yeah, see, because Elizabethan, right? So I'm stopping myself now before we go on to a whole thing about Queen Elizabeth I. Oh, look at that, Sir Walter Raleigh. That's what the capital of North Carolina is named after, Mr. Raleigh there. Okay, so now we know who that is. Now let's go back to the appeal. We know who Edward Coke is. Okay. Okay, Lord Coke. A juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, or the station in life which he occupies. I agree. That's good stuff, right? It was so written into our law as clearly as 1807 by Chief Justice Marshall in Wunber's trial 416. Okay. What is now called the Remmer presumption is far older than the 1954 Remmer decision. Private communications possibly prejudicial between jurors and third persons or witnesses or the officer in charge are absolutely forbidden and invalidate the verdict, at least unless their harmlessness is made to appear. Likewise, it is well settled that it is not necessary to show that the minds of the jury or any member of it were influenced. It is sufficient to show that intermeddling did take place to set aside the verdict. Too much strictness cannot be exercised in guarding trials by jury from improper influence. It has been said that the strictness is necessary to give confidence to parties in the results of their causes And everyone ought to know that for any, even the least intermeddling with jurors, a verdict will always be set aside. And that's from Massachusetts. This is the language of the Supreme Court of Massachusetts in a civil cause. How much more important it is to guard the purity of jury trials against improper influence when the matter at stake is the life or liberty of a prisoner. So criminal. And then there's a footnote here. I don't think that's all that relevant, or well, for what we're reading here. For an even older example, okay, we're going back in time further. Lord Delamere's case from England, 1685. Okay, Poot. Contrary to the state's position before the trial court, the court has not abrogated or abandoned this foundational principle that when the state's officials engage in ex parte communications with the jury during trial about the merits of the case, a new trial is required. Nor has the U.S. Supreme Court opened a door that could allow states to abandon that principle. All that has happened is a sensible restriction of the principle to exclude improper communications that do not bear the merits of the issue before the jurors. In the trial court, the state complained that this sort of tampering happens so commonly that it cannot overstate the impossibility of considering it a structural error. That exactly reverses the issue. Nothing like Miss Hill's conduct has ever happened before this case. Most likely it will never happen again. Well, I agree with that. The impossibility is found in excusing Miss Hill's conduct with post hoc reasoning that her tampering probably did not change the outcome of the trial, even though one juror said it did. She recanted it, Poot. She recanted it, though. Well, that's not even exactly accurate. She basically said that it was really more the other jurors and not what Miss Becky said. So I guess recanted it. I mean, it's an easy way of saying it, but yeah. If Miss Hill's misconduct is excused, then truly anything goes. Anything goes, guys. It's a free-for-all. The trial court committed legal error by not presuming Murdaugh's right to a fair trial was prejudiced by Miss Hill's jury tampering. Applying the correct legal standard, the evidence that an elected state official deliberately advocated for guilty verdict in the jury room during the trial so she could personally profit from it supports only one reasonable inference, the presumption of prejudice. I'm going to make a prediction right here before I scroll any further. I think they're concluding this entire issue on appeal. I think they're about to conclude this issue. This is their biggest issue. They had some other issues that were not as good. This is their biggest issue. I think this is going to be the end of this issue. Let's just see what happens. I have that feeling. That an elected state official deliberately advocated for guilty verdict in the jury room during trial so she could personally benefit from it or profit from it supports only one reasonable inference. The presumption of prejudice to Murdaugh's right to a fair trial is irrebuttable and constitutes a structural error in his trial. The court therefore should reverse the trial court and vacate Murdaugh's convictions. Okay, am I right? Am I right? Yep. We're on to the next issue. Now, it still has to do with Becky Hill, but it is the end of that issue. So, issue number 3. I think StreamYard did the spinning wheel. I just want to let you guys know, don't worry, I'm still here. So I was just saying that I was thinking back to part 1 when we were looking at the table of contents, and that of their different, I think, what was it? They had 8 or 9 issues, but anyway, that of their first, like maybe 5 issues or whatever, they were all Becky Hill, but just different facets of it. Again, pointing to the fact that the vast majority of their appeal is based on this Becky Hill shenanigans. So yeah. So then we're going to be going on to issue number 3. So here's what I'm going to do. So because I think this is a good stopping point, and I have another live stream scheduled for Adelson's. So we will, let me make a mark. So we will put a line right here. So we're on page 66 out of 132. Let me put my little mark because that worked last time. I just wanted a line. How did I do this before? Anyway, maybe I did a highlight. Okay, let's just see. So, oh, no. Okay. I just want a line. Oh, here we go. This is how I did it. This is how I did it. This is how I did it. Okay. This is how I did it. And it saved it last time. Yay! Okay. So now I know where we left off. So we will pick up with part 3 on this next time. So we made it 20 pages. Again, I don't think anybody else is reading this entire appeal, but you know what? If anyone's going to do it, going to go all out with Murdaugh, you know it's going to be this channel. So anyway, okay. So I'm going to go take care of Frodo real quick. I will see you guys back in just a couple minutes here for some more Adelson shenanigans. And love y'all and see you guys here very soon.